this thinking is what Steve was talking about. Judges are in this strange position. There's this sort of artifice in our legal profession that the judge has to put himself in the position of a reasonable consumer. We've got very sophisticated IP judges. They are very good on intellectual property. They are not very good on consumer behavioural science. So these comments are in the judgment of the interim decision. They are so out of date in terms of how consumers actually behave. This is the traditional thinking that Steve was talking about. This is, oh, well, name comes first. Name's more important. Brands are all about names. So when you look at AU vodka, it's all about AU. The other, the lookalike that's being sued is NE10, which is neon and its atomic number. Totally different to AU. Nothing like it. Well, conceptually it's quite similar. But more importantly, it's the least impactful part of that packaging. That is very, very impactful packaging. And it's not because it has the words AU written on it. So this is, in a way, what we're up against in terms of judicial thinking. And it's why the sort of analysis that we're talking about today and just thinking a bit more creatively about these claims and what evidence to put in is so important, because the judges aren't averse to this stuff. There's a judge called Mr. Justice Newey, Commercial Court, who took on board a whole load of expert psychological evidence on how unreliable witnesses are, witness memory, witness recollection. 10 pages of his judgment is warning all judges, when you hear a witness, they're not trying to lie, but they're reinventing history because they don't remember it and it benefits them. So you should give far less weight to witness evidence than documentary evidence. So the courts they're persuadable on this stuff. They just need educating. Brands need to run the right cases to educate them.